Hello. My name is Rob Porter. I'm an attorney here at the Spiggle Law firm. I represent employees in a variety of matters in the DC area, Virginia, Maryland, and in the district. And I'm here with Joanne Dekker. Do you want to introduce yourself, Joanne?
Hi, I'm Joanne Dekker. I'm also with the Spiggle Law firm representing employees in the DC area. Rob and I both also do federal sector employment work, so we can do that work around the country, and we have very successfully. But today we're going to be talking about private sector.
Yeah, I thought we would talk today about a common question that I get, and I'm sure you do too, which is what to do if you're an employee and you start to suspect that your boss is mistreating you, maybe retaliating or discriminating against you, maybe setting you up to be demoted or fired. Do you have any? So what would you say, Joanne, to someone who came to you with that kind of a problem?
Right. I think the first thing we have to remember is that bad management by itself is not illegal. So if your boss has singled you out or other people have singled you out, it doesn't necessarily mean it's illegal. So we're looking at separating that out from illegal conduct, which is covered under federal laws and state laws for age, gender, national origin, race, color, disability, genetic information, and retaliation. So we have to make sure we're looking at something that is illegal to be actionable. Although most employers now do have something in their employee handbooks that people will be treated with respect and they won't be harassed and bullied. So that's another angle, but it's not as strong, of course, as if it's a federal or a state law. Mm-hmm. You have to look at, is it something about me in particular that that I'm being singled out for? Is it my race? Is it my age? Is it my national origin? And then we have to decide what is going on and is it actionable or is it something else I should be doing?
Mm-hmm. So let's say that an employee starts to suspect they might be treated differently because of their gender or age, or maybe they had made a complaint about discrimination in the past, or about maybe they requested pregnancy leave or something, and they start to feel like they're being treated differently. What would you tell them to do?
The first thing we have to look at is the employee handbook, because that should tell you what the company's policies are and how to report harassment or discrimination if you see it in the workplace, if it's discrimination directed against you, or if you see it being directed at someone else, that should also be reported. So you go to the handbook first, and there should be a reporting policy in there that allows you to go to human resources. There may be a special reporting person that you go to. You don't have to go to your supervisor and tell your supervisor to stop harassing you because it's probably not going to go anywhere. So the employee handbook would be the first place to look to see where you go to report the harassment or the discrimination and who you speak to. The handbook should also tell you that everything is going to be confidential at some level, and that you should be protected from retaliation. And that's a hard thing to kind of get across, is that if you bring an EEO issue up, you should not be retaliated against, but employees also often fear it, and they often do get retaliated against. That's the bigger problem.
Right, and that's ultimately, I think, a question that only the employee themselves can answer is this bad enough that I want to report this to HR, who is not necessarily on my side. They tend to be on the side of management. Do I want to report this and potentially risk, retaliation, which if it occurred would be illegal, but is still something, you'd rather avoid if you could. So that's an issue that employees definitely deal with. I also tell employees that to the extent that they can, keep records of what's happening. Yes. Email, don't do anything against company policy, but keep notes to yourself. You can send emails to your personal email account and documents and so on. You know, a lot of employees come to me after they've been fired and cut out of their, you know, their work computer email access has all been cut off, and there's documents they wish they had that they don't have. And so it's good to the extent that you can and not violating any rules or policies, get those emails and documents that would help support your case, or just send emails to yourself about things that are happening. You can also send emails to your supervisor or a coworker, just, you know, like just to confirm we spoke today and here's what you said, or things of that nature. But that can be a little bit, it can come across as kind of aggressive if you start doing that. So those are the kinds of things that I advise clients to do.
Right. And one of the things that you should be looking at is exactly what is happening, what is going on. Did I get fired along with 20 other people in a rift because of COVID, or was I the only person to get fired? Mm-hmm. Am I being given more work assignments? Am I being treated unfairly? Mm-hmm. I look around and I look at my peers. You have to remember to look at your peers and who are your coworkers, that you're being treated differently from them, being treated differently from higher management, or maybe even, you know, lower line workers, doesn't necessarily mean you're being discriminated against. It means you're in a different group of people, so that a high level manager might be entitled to more time off or other benefits mm-hmm. than you, because you don't earn that money. I'm sorry, don't earn that earlier on. Mm-hmm.
So that's
something to look at.
Yeah, definitely. And so, I mean, that's one reason why I think people, you know, it doesn't hurt to talk to a lawyer if you think that these problems are beginning, because they can help you kind of suss out what the relevant facts are, and whether you might have a good case or not. Like you just said, it makes a big difference if you're being treated differently from people who have, let's say, exactly your same job, as compared to someone who has a different job, you know, or different responsibilities, because that person being treated better than you, it might be more difficult to argue that that's evidence of discrimination.
Right. Somebody in the sales group might be treated differently as far as bonuses as somebody who is in IT in the company, or somebody who is in a different department. So that mm-hmm. the salespeople, they get bonuses probably for their good work. The IT people are just working hard and maybe getting bonuses, but their bonus schedule is probably going to be different. Mm-hmm.
Or when it comes to people, you know, being allowed to work from home, or maybe taking days off and so on, you know, some employees, the employer will argue, need to be there every day, need to be there at a certain time, whereas others have more flexibility. And, you know, if you're being treated differently in terms of your work schedule than someone who has the same job as you, that's obviously different than if you are being treated differently from someone who has different job responsibilities. Okay. Okay. So one thing that happens a lot, or that I see a lot, is employees who come to me in the private sector and they've been placed on a performance improvement plan, sometimes called a PIP, or the equivalent of that, where their supervisor has told them, basically, your performance is not good enough, and you need to raise the level of your performance, and you have a certain amount of time in which to do that. Sometimes 30 to 60 days is pretty standard. So, and in my experience, I mean, not always, but sometimes that's a signal that the employer has already made the decision that they're going to fire you, and that the actual PIP is just a formality. But so what do you say to people who are in that situation? They've just gotten a PIP and they come to you and they want to know what to do?
Well, I've recently had an issue where the employee got the PIP, a 30-day PIP, and the the supervisor said, I know you're not going to make it. I'm just doing this to basically cover myself. So the supervisor had already made the decision to terminate, and they're just kind of going through this formality of a PIP so that they can get rid of the employee. And part of that could come out as far as you have to look at your employment agreement. If you've got one, if you're a higher level management, you might have an agreement that says, well, we're going to give you an incentive. If we fire you for cause, then we're going to put you on a PIP. So there may be a contractual requirement that they do something so that you can correct your performance. And the best you can do at that point, you kind of need to sit down and say, well, the writing's on the wall. I've been put on this PIP and I know they're going to fire me in 30 days. So it could be, if you've got a reason to say this is based on discrimination and not really on my performance, then a lawyer can step in and we can say, we try to cut that short and maybe negotiate a severance agreement if there's not already one on the table. If it's performance and you don't have anything to back it up as far as discrimination, then that's something we'd have to look at. I think more facts, be more fact heavy. So whether or not this is fair or unfair. And again, unfairness doesn't necessarily mean it's illegal, but that doesn't mean we can't help.
Yeah, and again, we're talking about the private sector. If you're in the federal government or in state, local government, you very likely have more robust protections when it comes to things like performance improvement plans. But in the private sector, it can be very often you don't have a real chance. Sometimes you do though. One thing I tell people is to make it as hard as possible for the employer to find fault with you. I mean, that 1 to 2 month period, just do everything that you possibly can. And to the extent that the PIP is vague or unclear about what exactly it is you're supposed to be doing and haven't been doing, try to get your employer to specify what exactly it is that is expected of you, and then make sure to create a record that you are doing exactly those things. And I would try to set up a meeting with your supervisor every week. And at the end of every meeting, I would send an email to the supervisor saying things like, thank you for meeting with me. We discussed my performance. I asked you if there were any issues. You said no. Just to have some kind of a record there that that happened, that your supervisor said, no, I don't see any performance issues with you this week. I think, if you want to fight for your job, that's the way to do it. Try to get as specific as possible. Yeah.
The other thing to look at in the private sector, and even actually in the federal sector, you can find this, if you're a member of a union. Collective bargaining agreements usually have some sort of disciplinary process in there. So if you're working for a restaurant or one of the grocery stores and they're unionized, there might be protections within the union for you.
Yeah, and an appeal process, maybe even.
Right.
Yeah. Okay. Well, I think that's those are all my thoughts on this. Do you have anything else? Any more thoughts on these topics?
Just like you said, Rob, if you think there's something going on and you're really not sure you want to see a lawyer yet, if you create that journal or create that email log where you're just sending yourself emails, because those are time and date stamped. So it's not like you have to remember time and dates, and then a year from now when your case is at a judge or something like that, you're like, well, I don't quite remember. But if you've got all these emails, that will help you remember. And it's a good record. It is date and time stamped for you.
Yeah, that's a great point.
And it helps. Right, and it helps be able to step back at some point and say, well, this happened all the time. Well, it happened in once in 3 years. 2 or 3 times over 3 years is not going to create a severe and pervasive hostile work environment. But if you're emailing yourself 3 times a week because the supervisor has done something, or your coworkers are doing something, because it could also be coworker harassment. If you're emailing yourself constantly, then there may be there's more likely there's something there that would be actionable and the employer would be willing to discuss.
Mm-hmm. Yeah, those are all good points. One thing that just occurred to me that I tell people too is whatever happens, don't lose your cool. That's what supervisors want. You know, when you send an angry email back to them or are short with them, that's the kind of thing that they can use to build a case against you. So, you know, do everything you can to just remain calm. Don't send off emails in the heat of the moment, and maintain a professional, polite, happy and eager kind of persona at work. Even if you know that your boss is out to get you, I think it's good to maintain that.
Yes.
Okay. Well, thank you so much, Joanne.
Thank you, Rob.
This was a lot of fun.
Thank you all for listening.
And all right, so we'll if you have any more questions, like along these lines or any or similar, and questions about your employment, then check out the Spiggle Law Firm.
Thank you.